This is English shorthand dictation number 337 and the dictation speed is 100 words per minute. Ready? Start. We have heard the parties as well as perused the charge sheet and the other materials on record. Full stop. The charge sheet sets out the contents of the FIR and refers to the materials that were collected in course of investigation. Full stop. The investigating officer obtained the call details record and customer acquisition form of the cell phones of the second respondent and the petitioner and had also attempted to obtain certificate under section 65 capital B of the Indian Evidence Act by approaching the relevant service providers but failed in his attempt. Full stop. He was informed that the conversations were quite old, comma, hence, comma, the requisite certificate could not be issued. Full stop. The charge sheet also recorded that the principal accused and the co-accused were yet to be arrested, and after their arrest, comma, separate supplementary challan would be prepared and presented before the court, semicolon. Nevertheless, comma, sufficient evidence on the file to prepare challan against the petitioner was available. Full stop. Para. In the course of hearing of this appeal, the petitioner sought for and was granted permission to file additional documents. Full stop. Soon thereafter, comma, the first respondent filed a reply affidavit dated 24th April, comma, 2023. Full stop. The application for additional documents contains several documents. Full stop. The first purports to be the translated copy of an agreement dated 23rd June 2020, entered into by and between the principal accused and the second respondent in the presence of two witnesses, comma, whereby the principal accused undertook responsibility of the entire amount of rupees 45 lakh received by her from the second respondent and also promised to refund to the second respondent the entire amount if, comma, for any reason, comma, the work to set up the proposed company did not materialize. Full stop. The second document is purportedly a statement of 23rd June, 2020 made by the principal accused undertaking to pay rupees 47 lakh, which she had received for business purpose from the second respondent, to the latter within a year from date. Full stop. The third document also purports to be the true translation of a statement of the principal accused admitting that there were discussions with the second respondent to promote and set up an Ayurvedic factory for which the parties met several times and that the principal accused received such amount of money as indicated therein. All these documents which the petitioner seeks to rely on, if genuine, could be helpful for her defense at the trial, but the same are not material at the stage of deciding whether quashing as prayed by her before the High Court was warranted or not. Full stop. We, therefore, see no reason to place any reliance on these three documents. The fourth document, which has been brought on record in support of the petitioner's claim for quashing of the proceedings against her, is the statement of the second respondent under section 161 of the Code of Criminal Procedure. Therein, inter alia, it was stated by the second respondent that rupees 9.50 lakh was paid in cash by her to the principal accused at a particular house where the principal accused, the petitioner, and their mother were present, and that on receipt of such sum of money in cash, they counted the money which was ultimately kept with the principal accused. Full stop, para. This, the second respondent said, happened in the presence of her sister-in-law. Full stop. It was also said by the second respondent in such statement that the principal accused, her husband, the petitioner and the other accused together have cheated her in a sum of rupees 45 lakh in the manner described therein. Full stop. The charge sheet contains a list of 27 witnesses who are proposed to be examined by the prosecution in support of the charges framed against several accused, including the petitioner. Full stop. Apart from the second respondent and others, this particular list includes the sister-in-law of the second respondent, who is said to have been present at house number 620 when allegedly the money changed hands. Full stop, para. This is a case where the charges have been framed and the accused are awaiting trial. Full stop. Having regard to the totality of the facts and circumstances, noticed above, we are of the considered opinion that the investigation and the follow-up steps are not so patently and unobtrusively defective or erroneous that allowing the trial to progress might cause a miscarriage of justice. Full stop. This is also not an appropriate stage to delve deep into the records. Full stop. It is no part of the business of any of the courts to ascertain what the outcome of the trial could be. Semicolon. Conviction or acquittal of the accused. Full stop. The small window that the law, through judicial precedents, provides is to look at the allegations in the FIR and the materials collected in course of investigation, without a rebuttal thereof by the accused, and to form an opinion upon consideration thereof that an offense is indeed not disclosed from it. Full stop. Unless the prosecution is shown to be illegitimate so as to result in an abuse of the process of law, it would not be proper to scuttle it. Full stop. The principles to be borne in mind with regard to quashing of a charge either in exercise of jurisdiction under section 397 or section 482 of the Code of Criminal Procedure, or together, as the case may be, has engaged the attention of this court many a time. Full stop. Reference to each and every precedent is unnecessary. Full stop. However, we may profitably refer to only one decision of this court where, upon a survey of almost all the precedents on the point, the principles have been summarized by this court succinctly. Full stop, para. Applying the broad principles as enunciated by this court, we hold that it is not one of those rare cases where the uncontroverted allegations appearing from the materials on record notwithstanding, it can be successfully contended that even no prima facie opinion can be formed pointing to commission of any offense by the petitioner, full stop. It is tried that the conspiracy to commit an offense is by itself distinct from the offense for which the conspiracy is entered into, and that such an offense, comma, if actually committed, comma, would be the subject matter of a separate charge, full stop.